Kindly proceed.
Your Lordships, the matter in this court is between Nambaja Community Association and others versus Attorney General and Chanja Holdings Limited. May it please this honorable court, I pray to state the facts of this case. The government under the newly enacted Urban Transformation and Strategic Infrastructure Act initiated compulsory acquisition proceedings of land that was supposed to be used for the establishment of the Greater Hatala Integrated Urban Development Project, a project covering approximately 2,000 acres of land, including registered Milo lands, customary lands, wetlands, and the sacred Chigwa grounds. Your Excellencies, the appellants challenge the acquisition process, the adequacy of compensation that was given to the affected residents, the legality of environmental approvals granted by NEMA, the legality of concession agreement, and the interference of the significant Chigwa grounds. Your Lordships, the High Court dismissed the application without delving into its merits, thereby prompting this appeal on 4 grounds. Your Excellencies, may it please you, I pray to establish the grounds due for determination in this case.
Please proceed.
Ground 1, Your Lordships, is on whether the land trial judge erred in law and fact in holding that the compulsory acquisition of the appellant's land and occupancy interests under the Urban Transformation and Strategic Infrastructure Act of 2025 complied with Article 26 of the Constitution of Gonja and the applicable laws. Ground 2 is on whether the land trial judge erred in law and fact in finding that the rights and interests of dead communities were adequately protected during the implementation of the Greater Hatala Integrated Urban Development Project.
Yes, Council, for us to be sure, are you raising the grounds for the appeal or the issues that you're going to resolve?
The grounds.
Proceed.
Much obliged, my lordships. Ground 3 is on whether the land trial judge erred in law and fact in holding that the approval and implementation of the project complied with Gonja's environmental laws, principles of sustainable development, public participation requirements, and the state's obligation regarding the protection of wetlands, ecological systems, and cultural heritage sites. Ground 4 is on whether the land trial judge erred in law and fact in holding that the grant of extensive development and leasehold rights to Chanja Holdings Limited struck a lawful and proportionate balance between constitutional land rights, public interest, sustainable urbanization, foreign investment, and community interests. Your Lordships, concerning the preliminary issue on jurisdiction of the Court of Appeal, the Court of Appeal has the power to handle this.
Look at the duty of the First Appellate Court.
Yes.
Kindly, before you delve into the Constitution or the provisions that allow us to entertain this matter.
As the First Court of Appeal, Rule 30, Sub-Rule 1 of the Judicature Court of Appeal Rules Directions, and according to the case of Chief Munte Henry versus your obligation to rehear a case by subjecting the evidence presented to the trial court to a fresh and exhaustive scrutiny and reappraisal before coming to its own conclusion. Much obliged, your Lordships. May it please this honorable court, I pray to advance my submission on ground 1.
Proceed.
Your Lordship, Transformation and Strategic Infrastructure Act and the compulsory acquisitions.
So, as you stated, the duty of the First Appellate Court, really so grievous stated that we have a duty to reevaluate, let us understand the matter as it was at the High Court.
Much obliged, your Lordships. The proceedings before the High Court were between the Nambaja Community Association together with Ja. My lords, the High Court challenged the following: the legality of the key provisions of the Urban Transformation and Strategic Infrastructure Act of 2020 concession awarded to the affected residents, the legality of environmental approvals granted by NEMA, the legality of the concession agreement entered into with Chanja Holdings Limited, the proposed interference with the Chigwa sacred grounds. My lords, the High Court ruled in favor of the government. The applicants contended that the government had violated constitutional guarantees relating to the proprietary rights, environmental protection, cultural rights, participation in governance, and sustainable development. It is upon this background that the Nambaja Community Association and affected residents appealed to the Court of Appeal.
Proceed.
Much obliged, your lordships. As far as ground one is concerned, my lordships, it is our submission that the Urban Transformation and Strategic Infrastructure Act of 2025 and the acquisition proceedings under it are unconstitutional as they violate Article 26, Clause 2B1 of the Constitution of the Republic of Gonja. Your lordships, I'll submit my argument in two limbs. The first one is on the supremacy of the Constitution, and the second one is the inadequacy of compensation to the affected residents. My lords, proceeding to my first limb of argument on the supremacy of the Constitution, Article 2.
Council, what do you mean by limb? Proceed.
Much obliged, my lord. Proceeding to the first limb of argument, which is the supremacy of the Constitution, my lord. Article 2 provides that any law that is not consistent with the Constitution is regarded null and void to the extent of its inconsistency. My lordships, the provisions under the Urban Transformation and Strategic Infrastructure Act violate this provision of the Constitution. While questioning the consistency of Section 7 of the Land Acquisition Act in the case of Uganda National Roads Authority versus Irumba Asumani and another, a case of 2014 in the Constitutional Court. Section 7.
The Irumba matter, the case you've just cited?
Yes.
So why are you opting to use the Court of Appeal ruling and leave out the Supreme Court ruling?
Much obliged, your lordship. The decision in this case is challenging the matters concerning compulsory acquisition, so I thought it wise to use it.
My question is, you are aware that we have a Court of Appeal, a Supreme Court decision in the matter? Yes or no?
Much obliged, your lordships. I beg your guidance on the Supreme Court case.
Counsel, you want me to read for you? So, because my question is, I'm not saying that it's wrong for you to cite that law, but the question is, what's the reasoning behind you choosing the Court of Appeal decision, yet we have a Supreme Court decision? You can proceed with the submission.
Much obliged, your lordships. In this case, Section 7 of the Land Acquisition Act was nullified to the extent of its inconsistency with Article 26, to the extent that it does not provide for prior payment of compensation before government can acquire land. In relation to the facts of our case at paragraph 7, your lordships, the provisions of the Urban Transformation and Strategic Infrastructure Act empower the government to acquire land and take possession of it, violating Article 26 of the Constitution, which is to the effect that lawful deprivation is made under a law that provides for prompt payment of fair and adequate compensation. Your lordships, it is our submission that this is a direct and deliberate subversion of constitutional guarantee. Your lordships, may it please this court, I pray to advance my submission to ground 2.
Before you proceed, what's your prayer on ground 1?
Much obliged, your lordships. It is our prayer that this court declares that the provision of the Urban Transformation and Strategic Infrastructure Act as regards adequacy of compensation be nullified.
Which provision?
Much obliged, your lordships, under paragraph 7 of the facts.
Which provision that you want this court to nullify?
The provisions of the Urban Transformation and Strategic Infrastructure Act.
The entire act or specific provisions therein?
Much obliged, your lordships, according to the facts of this case at paragraph 7.
Counsel, kindly, there are sections, state them, the sections that you want this court to nullify.
Much obliged, your lordships, the section in this case was not given. But they have given a provision, a sect of it, under paragraph 7 of our facts.
Kindly stated.
The Act empowered the government to acquire land required for strategic public projects. The Act also empowered the government to deposit assessed compensation in court where disputes arose, and to take possession of acquired land once compensation had been assessed and deposited.
So, counsel, in the premise, you're familiar with in this your Moot, they indicated that actually you are using the laws of Uganda, right?
Much obliged.
So, can you state the provisions of the Compulsory Land Acquisition Act that provides for that? Is it in your memory? Had you looked at it? Did you consider it?
Much obliged, your lordships, under section 7 of the Land Acquisition Act. Much obliged, your lordships. Ground 2. It is our submission that the land trial judge erred in holding that the rights had been protected as the government's process failed to recognize and compensate the distinct categories of land rights as enshrined in the Constitution of the Republic of Gonja. Your lordships, the rights in contention in this case are the right to own property and the right to enjoy security of occupancy. Your lordship, submitting on the right to own property under Article 200